Now I request Shri Amrit Bhargav ji to proceed with the panel discussion. Over to you. Dhanyawad.
Namaste and good morning to all of you here. And it's been, I think, 2 days now of this thought churning that has been going on. And there is so much to talk, there's so much to take away, and there is so much for learning and for acting on that, which is the most important part of any educative experience. So, for this session, which has been titled as Modern Law and Ancient Dharma Towards a Collaborative Jurisprudence, I agree with the thematic tone of the title in the sense that unless we know in what legal system we are in today, it's not possible to understand from where it all began or how things were before this came into being. In that spirit, we have curated this panel discussion with our two dignitaries on the dais. And by way of setting context for what we are attempting to discuss, this is like an umbrella theme. There's so much that we should say, and this is per se not a legalistic or a very legal kind of a presentation. It's meant for consumption by those who are affected by the law, which includes each one of us. And there are so many understandings and misunderstandings about the legal system. And many of us look to the law as if, it's a problem. How did this come to be? And what are the kind of issues that the legal system faces? Right from the text, the subtext, and the context of the law that we know today. From the abstract idea of dharma that enabled the practice and sustenance of local custom and usage, law was defined without verbiage, but in meanings and understandings. In the colonial age, law was constantly being defined and codified, not just textually, but through projects of the economies of politics, knowledge, and power in a way that their transactional metrics produced social and cultural genres that changed India forever. In that state of play, lawyers and their associated stakeholders contributed to the emerging culture of power and dominance with their tool of making the law through cases and mainstream the colonial legal system into the country's corpus of cultural understanding and ways of perception and cognition. Another strand of this journey is the setting up and the making of courts as institutions of law and justice, a process that created a new legal culture in colonial India. It is arguable that the colonial courts became the sites of engineering versions of selfhood and identities carved out of Indian social categories, and the theater of colonial rule was aptly supported and buttressed by the judicial system that was accepted and acceded to by the Indians in that phase of history. Now, all this is arguable. These are all propositions that historians have been making over a long period of time. This legitimated courts as the institutional frameworks of receiving, dispensing, and sounding out the metrics of colonial power and knowledge in the field of dispute resolution. We must understand that when you're talking about civilizational studies, cultural studies, there is a need to talk about what were the patterns of dispute resolution, what happened, and where it is today. There is a need to analyze that the means to the end of formulating a culturally stimulating model of alternate dispute resolution, ADR, which is spoken of today, that seeks to diffuse the docket explosion that has alarmed the state of the Indian judiciary. To underscore this, there is a need to reassess and reaffirm our understandings of the colonial past and its strange manifestations in the legal psyche. If knowledge were a tool of colonial power, history is an instrument of uncovering that basis of power as its content is demonstrative and deductive, both at the same time. The relationship between rights, power, knowledge, law, and its factual matrices in Indian society are indubitably interwoven in the nuanced network of psychology. It's all about the way we think and how this has influenced the mind in a way that is conscious, but can also be very subconscious, and we are not aware of it. But yet, it has changed the psyche. Litigation is a psychological process that adopts a legal genre for realization of its purported potentialities. When you start arguing a case or when a plaintiff or a client comes to us, we see it in a very different form. But by the time it's over, it's in a very completely a different shape. And then we have come to the end of it. In that exercise of potentials, the seamless interaction of rights, power, knowledge, law, and facts cast a spell of action and reaction that are possessed through the portals of historical investigation. The Constitution of India was a product of the colonial struggle and accepted the inheritance of knowledge and power with little negotiation in its core psyche. This was transformational, as the Constitution was both a manifesto and document for institutional governance. It later acquired a special status in the Indian imagination and interwove itself into the civilizational pantheon that is all accepting and embracing of identities and textual manifestation of ideas as the narrative that it holds. This journey of modernity affected India in the colonial era, and this touched upon the institutions of village and community which had relationships with society that are beyond the positivist meanings and comprehension. The defiance of colonial logic, an inimitable match of ideas that the colonialists subsumed in their statist preoccupation. I use that word because there is always a relationship between state and society that's very critical to our understanding. What was the place of the state, say, more than 1,000 years ago? And where is the state today? That is the story of what we're trying to investigate. With knowledge constituted their core in terms of authentic meaning and existence as living traditions, and thus became elemental categories for an ordered society. When you begin with a legal system, you create an order. What is that order about? It is part of the social order, it is part of the legal order. There are certain disciplines that we follow. Is it just civic sense? Is it just a cultural sense? It's much beyond that. This has resulted in what is today the individualization of society, which Mr. Sridhar Potaraju and I were just talking about in the morning, that was constitutionally recognized and boosted modernity's engagement in Indian social workings. With this is what I wanted to say just to begin with, and I'm sure that our learned panelists have a lot to add, and it is my pleasant duty to introduce both of them before we start. Mr. Arunesh Gupta is a senior advocate practicing at the Supreme Court of India since 1976 and brings with him a wealth of experience from his professional journey. Having served as Additional Advocate General for Rajasthan at the Supreme Court for over 14 years, his interface with public law and its practice is noteworthy. With over 10,000 court appearances and 500 reported judgments, he also served as the Honorary Secretary of the Supreme Court Bar Association and Vice President of the Supreme Court Advocates on Record Association. Following a multi-dimensional career path, he has his imprints on the formulation of legal policy as well. He has authored several books, one of them being the Srimad Bhagavad Gita, A Lawyer's Perspective. We are indeed happy that an accomplished son of a distinguished father, Justice D.P. Gupta, who served as the Chief Justice of the Rajasthan High Court, is with us today. Then our next speaker, who will speak after Mr. Aruneshwar Gupta, is Mr. Sridhar Potaraju, also a senior advocate practicing at the Supreme Court since 1997, and who completed his studies as the graduation in law at the Campus Law Center, Delhi. An advocate on record since 2006, he has appeared in a multitude of cases concerning nuanced propositions of commercial and public law. His contribution as counsel in the suit concerning the Ram Lalla Virajman will be remembered as a landmark. Also, an emerging writer, his latest book on the maxims from the Mahabharata provides a snapshot of his literary and academic pursuits. An intellectual by disposition, we are glad to host an illustrious senior counsel trained in the chambers of Justice P.S. Narasimha, currently a judge of the Honorable Supreme Court. That may I invite Mr. Aruneshwar Gupta to air his views.
Vanakkam, Namaskaram, and good morning. Good morning, everybody. Thanks, Amrit, my learned panelist, Sridhar, Suresh Soniji, esteemed guests, fellow scholars, and I've been hearing every one of them and I really enjoyed it. For the first time, I realized I'm in a real Devbhumi where people can talk in Sanskrit. So that was absolutely amazing. Ladies and gentlemen, today I stand before you to explore the intersection of Sanatana Dharma and modern law. As we navigate the complexities of our contemporary worlds and peep into the future, it is essential that we revisit the basis, objective, principles, and path of Sanatana Dharma and modern law and work out a collaborative jurisprudence if possible. I seek the indulgence of this august gathering to excuse me for two conscious misdemeanors. One is changing the subject of the session. I have substituted modern law and Sanatana Dharma with Sanatana Dharma and modern law. As Sanatana Dharma came much before the modern law, so it should have precedence over the later. Secondly, the spelling. Now, this is a very conscious effort which I have made. Some of the Sanskrit words that have no corresponding English words have been changed to the way it should be read by the common man like me and not the scholars in this gathering, because they can put a dot and put a up and then they read what they want to read and understand what they understand. I found my difficulty when I started translating Bhagavad Gita and when now I'm doing a work on Nyaya Sutra. So this was a big difficulty for me. So departure of some of the pronunciation standards established by some group of people, I don't know, because somebody said you must read when you translate Sanskrit into English, and I take this back to Max Muller, and they said you must read it like this. So I made a conscious effort to change it. Has been made for me as incorrect pronunciation of a word produces a different thought and leads to a complete misunderstanding of the word content. Every word has a content, a color, a vibration, a numerology, a meaning, which is totally lost if it is not pronounced and felt correctly, like Brahm and Brahma. Now, the interesting part is Brahma in Gita has been used 28 times, and Brahma has been used only once. And incidentally, in all, even Patnaik, who is creating a problem, Brahm, Brahma, and Brahman, the spelling runs the same. So for a common man to understand it like me, I found it very difficult. So I said, if I want to read Brahm, I will read Brahm. For Brahma, I will read Brahma. And for Brahman, I will read Brahman. So this is what an effort. Karma and karma, yoga and yoga. And the worst is Vesh and Veshya has the same spelling. So this is, and which makes a very total different impact. Now, there are three kinds of marked distinction going to the subject of that. There are three kinds of marked distinctions or fundamental differences between Sanatana Dharma and the modern laws. And this founds the basis of all the issues and all the problems. In fact, we are arguing some of the matters in Supreme Court, and that is where the fundamentals start. These distinctions led to religions based on personal experiences through traditional knowledge system, that is ours, on one side, and religions based on books or Abraham religions on the other side. These distinctions at the base of Eastern or the Western philosophies, culture and heritage, thinking process, and Sanatana Dharma and the modern laws. These three issues are concept of time. Sanatan Dharma believes in a cyclic spiral time and quantum existence. Modern law believes in lateral time and lateral living. Purpose and objective of life. Sanatan Dharma believes that realization of self or the divine cosmic energy within us is the purpose or objective of life. At the base of the modern law, the roots of which goes to conflicts. And I'll show how the entire law developed on conflict. So there's a relationship between the goal and the path. So the way you are born is the way you continue to exist. So if you are born on a conflict, you will always create conflicts. So it goes to conflicts, divisiveness, clashes of civilizations and classes, achieving power for dominance and control over others, and exploiting of the nature for a luxurious living. That is what the whole issue is. The third is the path or the process of achieving the purpose or objective. At the base of Sanatan Dharma is the great principle of karma. Everyone has to perform own karma to one's own perfection and enjoy the bliss in performing whatever work one gets in hand. And that itself leads to detoxification, purification, spiritual growth, experiencing and realization of the cosmic self within us. Mutual respect, conflict-free individual, and a conflict-free society. The modern law is external, based on conflicts. Man versus nature, dominant versus subservient, superior versus inferior, ruler versus ruled, kings versus churches, male versus female, white versus rest, rich versus poor. It's all conflict, conflict, conflict. So they continue to fight. Now coming to the concept of time. At the heart of Sanatan Dharma lies the concept of Kal Chakra, or the cyclic spiral time, without a beginning and without an end. And at the end of, and the heart of Abraham religion is a lateral time, which has a beginning and will end on a day, the day of judgment or Kayamat Ka Din. Now that is the whole problem. The whole conflict is on the basis of these. Now why I'm talking about all this? Because this is the Kal Chakra, and what I say is that Brahm himself or itself is bound by time. So there's a Kal Chakra, which is cyclic time, and most of the people already know here that the times taken by sun ray. Now this is the beginning of time in our system. Is the time of a sun ray to move through 3 atoms is 10 raised to minus 17 into 3.375, which is called a Truti. Now there's the error. Then comes the Veg, Lav, Nimesh, Kshan, Kshata, Lagu, Nadi, Muhurat, and goes on and goes on. Now this I am only showing to show that even Brahm in our system is not free. It is also bound by laws of cosmos. Brahm is bound by a structured cycle with no escape. With the awakening of the Brahm, the manifestation goes to Ardhnareshwar split, dividing into 2 fundamental aspects of Purush and Prakriti. The Purush, and that is where I'm just trying to develop this as a base of the fundamentals of laws that we had and the fundamentals of law which they developed. So at the base of us is the immutable, Purush, imperishable, absolute truth, blissful, which is the true nature of self within our individuals. The Prakriti, which is mutable, ever-changing aspect comprising of physical world, including the human body, mind, intellect, ego, and countless attributes and aptitudes and attitudes. Now, this is where the whole, yesterday, Sudhaji made a distinction that Ved is something like a Purush and Vigyan is something like a Prakriti. So those two are two totally different approach, 2 different streams of thinking. Now, the primary object of the Sanatan Dharma is to guide every being in realizing and experiencing the self within. This ancient philosophy provides a comprehension framework of understanding the ultimate truth, enabling seekers to attain self-realization through surrender. Sanatan Dharma focuses on internal conflicts, helping individuals become conflict-free by acknowledging respecting the differences inherent in the Prakriti. By embracing this way of life, individuals can realize their true nature and attain liberation. Sanatan Dharma or Hinduism is therefore a way of life designed to facilitate self-realization and help others achieve their objectives. Sanatan Dharma therefore provides for various aspects of self-evolution, including responsibilities and obligations of rulers, spiritual leaders, traders, workers, yogic practices, spiritual disciplines, spiritual guidance. And these spiritual guidance we get from the various scriptures around us, the epics around us, the books around us, the smritis around us. So we got Ved, we got a Brahma Sutra, Nyaya Sutra, Upanishads, and Puran. So I'm making now, my real effort is to find out how much law, where we talk of law, and my learned senior here, he has done a very good maxims in Mahabharata. So this kind of Mahabharata, but when I started translating it, I really found that the translations and all those things which people have written, they are more from the script, from the scholar side of view, but not from the, the common man's point of view or what you teach to the young generation. So it's all missing. So we are making an effort to get into it and translate, get the correct translation. And that is what I found a very, very interesting issue when I wanted to do Manusmriti, the Nyaya Sutra. Now, the Nyaya Sutra itself, and when I talked to the scholars, they started saying, well, Nyaya Sutra, ultimately it is this. There are 16 characteristics, and these characteristics are there to help you to get moksha. Now, I said for moksha, there is already Brahma Sutra. And incidentally, I had read Brahma Sutra by Dr. Panchmukhi. In fact, Justice Venkatramaiah has directed me to Justice Panchmukhi, Dr. Panchmukhi, to find out. He had done a very good translation on, but from the Madhvacharya point of view, not from the Ramanujam point of view or the Shankara's point of view. So I said, so why Nyaya Sutra has something to do with Brahma Sutra, from ultimate realization of your own self. So when I started doing it, so Praman, Pramay, Sanshay, Prayojan, Drishtant, Siddhant, Avyav. So this is what we are trying to do. Putting each letter, Avyav, Tark, Nirnay, Vad, Jalp, Vitanda. Now this was very interesting. What is Jalp, Vitanda, Hetvabhas, Chal, Jati? This has to do with Brahmgyan. But then it has something to do with judicial excellence. Now, if you want to be a good judge, these are the qualities that when I translated it, I said judicial excellence is achieved by understanding the evidence, Praman, issues, yearning to do justice, motive, illustrations, doctrines, sections of law, logic, capacity of decision making, entering into generative dialogue, understanding futile arguments, irrelevant issues, confusions, tricks, domain knowledge in the court. Now that Nigra Sthan is a place where Doodh ka Doodh and Pani ka Pani happens. It divides. So that's a court. Today language, that is a place, so Nigra Sthan is that sthan, where ultimately, and that leads to final justice. So this is the structure. So these are what I'm trying to say is that you see from the Sanatan point of view, we continue to evolve and create it for the purposes of ultimate benefit for the public. As Soniji said, ultimately, what is the purpose of why are you doing what you are doing? And then the next sutra is that now this is where the law comes in. The direct perception, assumption, similes, and experts' account constitutes evidence. So they go into the formation of evidence. But I think we are still at a very, very initial stage of I am. And I have not been able to get, and I don't rely on anybody because as a lawyer, I have to apply my own mind. So this is what the translation of the Nyaya Sutra is already read. Now then coming to the modern laws, what is the issues? Now the problem with the modern law is that I have divided the modern law into 5 time zones. So the original time zone is prior to 1215, which I call the legal revolution 1.0. Because today, everybody talks of globalization 4.0. They talk of 4th industrial revolution. So as a lawyer, I was wondering what was the legal revolution 1.0 or 2.0. So the first legal revolution, which I call, is prior to 1215, where there's no legal structure. Rules made and litigation adjudicated by family heads, tribal heads, or kings. Royal charter, which we call as a chancellor's foot. So anybody can decide what he wants to decide. He says you are right and you are wrong. So it's that's the way it is there. So this justice was raw, centralized, and embodied in social hierarchies. Then came in 1215 was a turning point in the British era. And that is where the fight between the royalty and the parliament, so that the parliament came in. So came in what is called the Magna Carta. The Magna Carta did not get implemented in 1215. It took a lot of time. But Magna Carta arose out of a conflict between royalty and the churches. So rise of the rule of law, curbing monarchical power, codification of laws, rise of corporation. Now this is very interesting. How after 1200 onwards, 1400, all the four Britain, Dutch, France, and Spain, they came out with corporations. And these corporations were given rights to trade with various countries. So one of them walked to India, and so East India Corporation came here. And they realized that everybody is fighting here. So ultimately there are 582 small, and then everybody internal fight and external fight. So we are all fighting. So they took the advantage of that. So whatever the right from Huns till 1757, whatever the destruction had taken place during the Islamic age, they took it over and they destroyed it and they looted. So that the loot, plunder, and that started with, and that really led, in fact, there's a very interesting chapter on how the Industrial Revolution started in 1770. And the entire Industrial Revolution started as a result of the loot from India, which went to Europe. And that led to virtually the part of the second industrial legal revolution. The third legal revolution is the period we witnessed judicial independence. So royalty, it shifted to parliament, then it shifted to judiciary. And the rise of individual rights, the constitutional democracies after American and French Revolution. So in fact, the turning point was the American Revolution, where the concept of, though the concept was that judiciary is weak, but there came up the concept of an independent judiciary. Then the legal system emphasized on personal freedoms, equality, and justice, reshaping the relationship between the state and the citizens. Then came the fourth industrial revolution, fourth legal revolution, and this is post-independence so far as we are concerned. So now we are in 1985. So globalization expanded the legal landscape is beyond national boundaries, introduction of alternate dispute resolutions. This era saw cross-border mechanisms for resolving disputes, reflecting an interconnected world and need for flexible collaborative justice approaches. Now, this is all continued till 2020. And then suddenly there's a cosmic kick, COVID. So suddenly the dimension shifted. And that's a very interesting part of the human civilization, and it will go down the history. Because this is where the whole dimension, the human dimension shifted from the 3D dimension to a 4D dimension. People suddenly started thinking of metaphysics. They started thinking of environment. They started talking of health. So when you see people sitting in restaurants, and when you go to the airport, you'll say earlier they used to talk of all material development of cars and everything. And then they suddenly started talking of health. So the cosmic COVID kick has shifted the human consciousness from third dimension to the existence, to the humanity, to the fourth, and the fifth. I don't know whether people have seen Interstellar is a movie where he's talking of the fifth dimension, where there's an emotionality in the spirituality. Because spirituality doesn't have emotionality. And this is exactly where they are coming closer to the Sanatan Dharma. There is an emotionality. Modernities, this has led the modernites and the post-modernites to human-centered dispensation of justice, which is the core of Sanatan Dharma. Shift from adversarial litigation to conflict resolving with empathy and intended beneficiaries and stakeholders. Conflict-free individual alone can lead to a conflict-free society is the bottom line. And that is exactly what we have been talking all over, every time. The whole Sanatan Dharma is based that the whole Gita is based that from a karta you become a drishta. You become conflict-free. Don't have a futuristic trauma. Don't bother what is going to happen. Do your work to your perfection, enjoy what you're doing, and that is what you take. The need of having an integrated view of the whole cross-border collaboration to manage global healthcare had led to development of a collaborative justice. West has no option. They have no option but to change, and we see this as they're accepting the Yoga Day and getting deeper into the accepting Ayurveda and meditation as a necessity of meaningful existence. And all this I have done in a book which is called The Legal Revolution 5.0. Thank you.
Thank you, sir, for your very succinct presentation, and we are just on time. So may I now request Mr. Sridhar Potaraju to take the floor.
Gurubhyo Namaha. My pranams to all the Gurujan and fellow seekers. After the erudite presentation of Learned Gupta ji, I think I have a very difficult task of trying to add some value to this discourse, but I'll do my best. My approach to law has been quite interesting. I thought law as a medium of social conflict resolution and a play of words. That's what brought me to law. Because law gives you an opportunity to see the social conflicts and also the challenges that society faces at multiple levels, right from an individual level to the larger group and community levels. I mean, to wit, a custody battle of a child actually affects the child the most. So at the individual level. On a higher platform, we talk about the group or community rights, whether a particular institution is a minority institution, which would result in the larger sections of the population being deprived access to those universities or colleges, or group rights. Now, when we see these kind of conflicts in society, the question that which comes to our mind is, what is the premise or the edifice on which we are trying to deal with these conflicts in the society? We have two models to look forward to. The model that we have adopted post-independence through the written constitution, which is nothing but an inheritance of the colonial legacy of an adversarial system of justice administration. When I mean to say adversarial system of justice administration, as a practicing lawyer for 27 odd years, what I found was this has become a debating club where the best debater wins. Justice is either incidental or accidental. Unfortunately, that is the truth of our administration of justice. Because the most logical argument is what is being persuading the courts to reach to a conclusion, because reasoning is the soul and heart of a decision making. Sans reasons, a judge cannot by instinct take a particular perspective or a view. So when we look at this structure of administration of justice, there's a lot of burden on the judges to actually administer justice in accordance with the laws and also the constitution as the guiding light. Now, what are the parameters that are available to the judges, if you look at it from that perspective, or as lawyers, as practitioners of law? Now, either we be guided by our constitutional ethos and values, or we go by the debating club rules of winning the debate, whatever it takes, Jalpa, Vitanda, whatever modes of debating which is available at our disposal. At this juncture, we need to look at the constitution closely and the value systems which have been actually underlying in the constitution, which connect the current day constitution and law to our ancient values. Why do I say that? Because the constitution as drafted and as enacted and brought into force has beautiful epigraphs which acknowledge our glorious past, which actually connect us back to the values and the role models we had in the past. So Vedic times, Ramayana times, Mahabharata times, etc., to contemporary history. So we acknowledge all. I mean, as a true Sanatani, we do not deny. We don't live in denial. We accept. So we accept time as the most powerful, and the passage of time leads to consequences which may be good, which may be bad. We accept both. with a sense of detachment. When we look at it in this perspective, what we are seeing is that there are certain values which have been eternal in our lifespan and also the life of this nation. Sanatana as eternal dharma is probably the oldest rule of law civilization which exists on the planet. Rule of law as a concept has been conceived in order to put a leash on certain religious authorities' control over the political and individual lives of the members of those societies in the West. Whereas we as a society governed by Dharma, Dharma is something which governs us as a unison. Dharma is not pigeonholed nor compartmentalized. So our Dharma is very harmonious, and then everyone understands their Dharma very naturally, probably because that's part of our cultural and civilizational ethos and our traditions. We understand it. To put it simply, the Dharma of a brahmacharya ashrama is probably to study and perform your duties in your Gurukula or in your school or in your college or in university. Similarly, the Dharma of a teacher is to actually provide knowledge of all the Shastras which the Guru is qualified to teach, and also present diverse perspectives and encourage the pupil to understand and debate on it and come to his own views as to continuum of that process. So when we have these kind of dharmas which are very clear, speaking in a university campus, I took the examples now. A Grihastha ashrama also has its own dharmas. So now is alimony a dharma of the husband? Bharta, with its Sanskrit roots, is a person who's required to take care. So therefore it's a dharma, and that is the principle on which modern maintenance laws and alimony laws are actually being interpreted, irrespective of the capabilities of the working woman. So this dharma has always been prevalent in our subconscious and has been applied by us at various levels. I recall in my grandmother's native place where we used to go, a person who's seeking alms would also come and say in Telugu, Dharman chayandi. So please perform dharma. So what is he asking? He is asking a grihastha to perform his duty to support the people who need of food or support. So that is the ashrama dharma of a grihastha. Now coming back to contemporary times, if you look at the society or the value systems that the law seeks to enforce, what becomes enforceable becomes law. In the absence of that, it is only a moral intent. Like you have to do your homework. The consequence is probably a reprimand or a punishment in the school or the college. You should attend classes. You are absent, you will not be given your hall ticket to write your exams. There's a consequence. But there are many things which have no consequence, which are only moral in nature. You should not lie. So is there any consequence? Unfortunately, the legal system that we are in, there is no consequence of actually perjury. People who lie through their teeth get away. So that is a part of the problem, where the value systems which are naturally available to us at our own understanding are not translating into real life implementation and administration of justice. In this context, now we also may have to look at what the constitutional framers try to give as the most important direction, if they can say, because constitution is a live political document which talks about distribution of power and how those powers have to be exercised by different organs. In this context, if we look at the motto of the high courts, or which is the national motto, Satyameva Jayate. So what are they saying? That truth should prevail. So if truth should prevail, then how does a debating logic alone prevail? So that's something which we need to consider, whether these adversarial methods of adjudication are the right remedies available for resolving conflicts. The failure of that mechanisms is the admission or the need or promotion of ADR, where you're going back to the traditional methods of conciliation, using the good offices of elders in the community or the family or the businesses, wherever the conflicts are there. So the reconciliation effort or conciliation efforts have now been statutorily recognized. So the alternate dispute resolution is one such measure, which is an acknowledgement of the failure of your adversarial system where the logical arguments alone happen to dominate rather than truth being prevailing in a system which is governed by law of evidence and procedural laws. Similarly, the Supreme Court is also guided by Yato Dharmas Tato Jaya. Now, therefore, the Supreme Court is guided by doing its dharma and ensuring that wherever dharma is ensured of its victory. Because the core value of a society lies in people who are truthful, who are honest, and who actually perform their dharma. So those who perform their dharma believe that dharma rakshati rakshitaha. So the dharma that I perform will come to my aid or protect me. So to ensure that faith continues, otherwise we become a adharmic society, which probably to a large extent we are already. Probably that is also because of the Kala Prabhava, we are in the Kali Yuga. So probably the nature of Kali Yuga is such that adharma would spread because dharma is on one leg. But nevertheless, efforts to strengthen that one leg of dharma in the Kali Yuga also has to be guided in the judicial space by certain core civilizational values or probably methods which were always available. Now, when I say methods, what are the methods that we are talking about? We are talking about a method where you understand the need of the society to have dharma as its most sacrosanct value, dharma to be determined in a manner which is consistent and is irrespective of who's seeking dharma. Here I may recall the anecdote where Draupadi is brought into the Kurusabha in single ropes, and she raises very good logical questions to which the scholars in the Sabha refuse to answer. They pass it off. The most profound one is Bhishma says, Yudhishthira knows Dharma, so you should ask Yudhishthira. I would recall that at a later stage of the Mahabharata, in Shanti Parva and Anushasana Parva, where Bhishma Pitama is on his bed of arrows, Yudhishthira goes to him and to learn Dharma Shastra. At that stage, after the entire discourse, I mean, Yudhishthira becomes relatable to most of us who are not been very good in academics. Okay, you said all those things, but I don't understand anything again. So please summarize. So Bhishma says that you do what I tell you to do. From a Bhishma who refuses to perform his dharma of telling what dharma is, when Draupadi asked in the Kurusabha, his own evolution to tell Yudhishthira that do what I say, that is dharma, is the evolution of probably the characters of Bhishma as well as Yudhishthira. So that contrast, if you notice, is the evolution which is open to everyone at every stage of life. So Bhishma Pitamaha, from the Kurusabha to the Kurukshetra, would have been a few decades in that long span of life that they had with Swachhanda Marana blessings that he had. So that shows something that we are a value system based society where we actually mull over our values and then we refine them. So at a given point of time, our understanding probably is clouded by the information available, perceptions, prejudices. But we are bound by an open mind to actually consider anything which comes our way and then evolve. So it is in that process of evolution that the laws also have to be considered and seen. So that is the amendment processes which we see the parliament or the state legislators undertake to meet the contingencies of the situations which arise in the society. Now, coming back to the integration of the concepts of dharma or satya to the contemporary times. There was a gentleman who had come to me a few months back. He was saying we should have a law which actually punishes persons who lie with the most severe consequences. Because he said a society where lying is actually not even considered an offense is the worst kind of society that we live in. So when that's something for the probably policymakers to actually ponder over, because there's so much of duplicity in what we say and what we practice that this gets away. Because everyone is doing the same thing. So what you preach and what you practice are completely at variance. Now, whether that is permissible. It is permissible in a Western jurisprudential context because you have the art of segregating subjects. Like what he does as a particular legislature has nothing to do with his personal life. That's the value system that we are segregating. Similarly, you say that each part of the law is independent of the other. So therefore, we are pigeonholing the values of the society and then looking at them in a myopic way. And to just take a cue from Soniji's speech about materialism, if you look at the social values also of the West, they are ism driven. Either it is socialism or communism or capitalism. They all are trying to control the material resources and the land and the wealth and the people through the control of those material resources. On the contrast, if we look at our own civilization, we are a dharma-based society where our value system teaches us that dharma, arth, kam, moksha are actually the purusharthas that a person should pursue through his brahmacharya, grihastha, vanaprastha and sannyasa ashrama. So it gives you a very clear roadmap as to how you have to live a life from your birth till the day you choose to leave the body. So the values that are there here would have to be harmonized into all aspects and not keep them separated. So there could be a confusion as to what can be a Samanya Dharma and what can be a Raja Dharma. Again, both are dharmas to be performed in different roles. So in this context, if you look at it, again from Mahabharata, there was this episode where Prahalad's son comes to Prahalada and says that I'm in context with this Rishi Muni who claims to be superior to me, but I believe I'm superior. So you please adjudicate, and both of us agree that the only person who's fit to adjudicate this contest between both of us is you. So instinctively the father says, how can I be a judge when my son is before me? Then his guru tells him that as a king, you do not have a choice of not to perform your dharma as a Raja when there is a conflict which is brought before you. It's your dharma to actually adjudicate the dispute, and he does to the peril of his own son, because upholding dharma is the value that he chooses. Similarly, you find the character of Gandhari, which blesses Duryodhana only with Yato Dharmas Tato Jaya, not Vijayi Bhava. So the value that dharma had even for a mother was such. So therefore, what I'm trying to drive home is that the modern law or the Sanatana Dharma, as far as the Indian context is concerned, within the framework of our constitution, can be harmonized and can be actually applied on a regular basis in a court of law or in our daily conduct. So therefore, people acknowledge dharmic conduct and they socially also acknowledge it. Now, that acknowledgement alone is not adequate. So we need to give content for that. So now, what is the content that we give? Is a clarity of understanding of the concept of dharma. At a point, in fact, I happened to ask Parasaran sir as to what is the dharma when you want to do some charity. So the principle that he told me was anayasena. So you should part with things which you can part and still not think about or regret having parted. That is a simple measure. Now, once we teach these small principles of dharma as a part of the curriculum of law, then we would know exactly what are the values and the principles behind it. Because the modern curriculums of law universities do not teach these values as part of their curriculum. They're only teaching statutes which are being enacted. And then they go back to the common law methods of our colonizers. So there's nothing to bridge this gap to bring in our Indian value systems into your legal education. Unless the legal education is taken care of, the question of going back into a Sanatana Dharma based society, which could be the larger dream of a dharmic society. Dharmic society here means where everyone has the freedom which a Sanatana gives to a Charvaka or a Vaishnava or a Shaiva or someone who's confused or someone who wants to accept all. So that freedom is something probably what we have to cultivate. Similarly, we have an opportunity to actually classify debates. I think that's one thing I've been talking about. with a lot of scholars informally. The law schools don't teach the art of debating anywhere, as I've come across. The most critical part is to classify a debate either as a samvada, vada, jalpa, vitanda. I, with my little Google access, try to read about it and understand that there is a classification. This is not being taught in law schools. I'm focusing on the academia qua law students because I come from the legal background and I see exactly what is lacking there as a practicing professional. So I guess that is where probably the universities should step in and then build curriculum to actually encourage people to know the art of debating and what is the object of the debate. The object of debate is truth, not winning a debate. As long as the participants understand this, I think we will have a dharmic society because the councils representing either sides are actually trying to strive their own best to ensure the judge administers justice in accordance with law and it furthers the cause of dharma and satya and not merely scoring a brownie point on some debating logic. I think with these thoughts, I take leave and I am grateful to the organizers, Shastra University, Vijnana Bharati, for this opportunity. Thank you.
So now we have covered a vast ground of law and dharma and also seen what it is to do a survey of the legal system as it was, what should be issues that confront us. And let me engage the two of our panelists for a while before we throw it open for questions. In fact, both the books that each of them have written, one by Mr. Sridhar Potaraju, The Maxims from the Mahabharata, and the other by Mr. Arunesh Gupta on the Srimad Bhagavad Gita, a lawyer's perspective. I truly believe that both of them can be of value in the Indian knowledge systems framework in the sense that it gleans from not just the textual view, but from what both of them feel about these two texts and how it is related to them. Ultimately, as I also tried delineating in the introduction, law and litigation in India has been very psychological. And when we speak about alternate dispute resolution came into being because there were difficulties with the formal litigation process. And how did that come about? When people know, in the light of their cultural behavior and the periodization in history that they live, that there are legal remedies under certain enactments and they can be sought out in courts of law that can give you a judgment that goes either way, there is a temptation to use that remedy. And this is widely documented in anthropological works over the 16th, 17th, 18th centuries. And what was written in the 20th century? Well, much of the epistemic of in what sense were all of that written can be challenged. It can be. There is a lot of work going on there as well. But when we look at certain accounts, whether they're prejudiced or not, we come to know especially about litigation, the pattern of litigation. It's very important for lawyers and stakeholders to know that when you have a remedy, people seek that remedy. And the system starts working. And it works in a way that may not be palatable at the end. There is a lot of excitement, like we always say that once when a case is filed and it comes for hearing initially, but when the case goes on and on and on, and when the final hearing comes, the whole theater is different. It is not just because of the lawyers or of the legal system, because the case has progressed in a certain way. And how is it conditioned? We were talking about the fact that the legal education curriculum lacks any training in Indian knowledge systems. That has to be addressed because you will have to deal with the patterns of dispute resolution itself. Certain eras in history produce certain powerful changes. And whether we may like it today or not, what has happened can't be easily undone. So there is a need for a very pragmatic and a practical outlook on Indian knowledge systems in the legal education framework. Is seems to be one of the takeaways from the panel discussion. And what I wanted to ask both of them is about their books. And first, let me ask Mr. Sridhar Potaraju and then come to Mr. Arunesh Gupta.
Well, my book was a journey of probably reaching a point around 2012, 15 years into practice, that I had hit a stage of career where I was in need of some additional inputs to improve as a professional, jurisprudential input. So first instinct was like, should I go to the West, some university, and probably do a course there? But somehow I was never inclined to do that early days also. So then I thought about it, and somehow instinctively I knew that probably Ramayana and Mahabharata have a lot of jurisprudence embedded in them, especially Shanti Parva and Anushasana Parva of Mahabharata, and also Ramayana also. So that also, because I felt that probably reading merely law will not take me far, because for me the Purushartha is moksha, not only money making with law. So therefore I thought, let me pursue this reading. So I started with Valmiki Ramayana and then into Vyasa Mahabharata. And then while reading, I started making notes. Then I observed that there's so much of nuggets of wisdom which is hidden in the ocean of knowledge of Ramayana and Mahabharata. And those pearls, that when I saw them, they like are in abundance. And they are absolutely, they won't get exhausted. I mean, me picking up a few and bringing it in the form of a book. So I realized that probably I should share that experience that I had of the great values that have been actually discussed in the context of a very simple story. So that's probably what triggered the book.
Thank you for asking that question. It's a long story. My grandfather was a spiritual leader in his own way. He was the first registrar of the Rajasthan High Court. In fact, he was the senior most district. He gave me the first book. I attended Swami Chinmayanand lecture in 1974 when I was 18 years. And then my grandfather presented me with the first Bhagavad Gita. I was a voracious reader. I used to read a lot. And after reading, it was one by Swami Chid Bhavanand from Kerala. And I think that is one of the finest interpretation I've read. I was extensively reading, so I read Aurobindo, I read 7 volumes of Vivekananda, I read at least 30 books on Gita, Tilak, Vinoba, Gandhi. And I really found out that everybody has interpreted Bhagavad Gita, but I didn't have a bare act of Bhagavad Gita. Now, when I had a chance to visit New Zealand on the first Hindu conference in 2007, in fact, I wrote a book. Originally, I was thinking of writing a book called Self to Self. And I gave it to Justice Venkat Chilaya, who wrote the first preface of my book in 1988. And he really felt sad about it. He said, lawyers don't read. If they don't read, they don't think. If they think, they can't write. So I'm happy that at least you're writing something. So then the journey went on. I continued to read, and I read a lot of on economics. I had clients were coming, so we had a lot of issues. Incidentally, in 2008, I visited the New Zealand where we had the first Hindu conference, and the Prime Minister of New Zealand was there. It was a small group, but then I realized why Prime Minister was there, because I suddenly realized that Maoris were there. The chief of the Maoris were there, and then I met a lot of people. Like I met the chief of Mayas, I met the chief of American natives, his name was. And across the board, I realized that this vertical divide between the books, the religions of the books and these all other were totally different. And we didn't have a bare act of Bhagavad Gita. Then I had a conference. It was one of the first diaspora conference in Chicago. And again, the same problem, I realized that people had no idea, because everybody was bogged down by Max Muller. And there's a classic book which you can find on the roadside. It's called the 100 Great Books of the World. And number 4 is Bhagavad Gita. It says one of the best translation of Bhagavad Gita is by Sir Edwin Arnold. Now, when I read, I said, oh, that is not the only, but there's the only book I have not on my table. So I went and bought Sir Edwin Arnold. And when I started reading it, after 3 or 4 sutra, I realized that if somebody reads Bhagavad Gita from that, he'll never read Bhagavad Gita again. So that made me write my first edition in 2009. And then I continued to refine. In fact, this book, I got a lot of appendixes where I pull the Kal Gandha issue. The real issue is, you see, we don't have Krishna to teach us Bhagavad Gita, and we are not Arjun. There are so many things at that point of time which Arjun could relate. Like Rudra. So that all in entire chapter 10 talks of, there are 76 attributes of Purushottam. He says, I am this, I am this, I am this, I am this. And nobody can relate it. So the young generation can't relate. So in fact, one of the things, because when I started in fact talking on Clubhouse, and I realized that within a period of 2 weeks, I had 2,500 followers. So I stopped it. I said, I don't want to be a spiritual leader in that sense. But then what I did was that I realized that how to read Gita is most important. And the difficulty is the second chapter is a Sankhya Yoga, which is the most difficult. Because you see, in fact, like I said, the cosmic kick, Arjun wanted a cosmic kick. So in the second chapter, Krishna gives him a kick. So that he starts thinking, but he didn't think till chapter 5. He didn't start thinking even. He just had rushing questions after question after question. So in fact, if you want to read Gita, you should start from chapter 16, where you have a distinction between the Asur and the divine. And the Asur, which I call the people who have no music in their life, who can't be trusted. So they are the toxins. So the first issue is how do you deal with them? So I really use this book to talk to people. And therefore, I put a lot of appendixes and a lot of, again, the issue came of Sanskrit words and all. So this is still a journey. We have to do, I've done my Upanishads and I'm trying to do Nyaya Sutra and more to come. Thank you.
So now we can have some questions from the audience.
Thank you, sir. Namaskar to all of you. And Amresh and Gupta is nicely explained about the Bhagavad Gita, all the things, and he's doing a lot of work. He talked about Nyaya Shastra and modern laws, and there is spiritual laws also. And people may escape from the Nyaya Shastras and modern laws. One cannot escape the spiritual laws, karma. One has to undergo. That's what. They have to undergo the 84 jivas. Our aim is purpose of life to supreme abode. And Mr. Sridhar also nicely explained so many things. And law of life is also important, actually. And how to make the laws is also important as policy makers. They're important things, and these are not being taught in our education system, actually. If you are taught by now, I think we are a good society would have been. But not too late now. What we had as Sanatana Dharma so far, that time science was not there. Now science is there. We have a spiritual and science, we can go further. And the knowledge system is doing very well. I think we can propagate for the society. Thank you, sir. Apart from this, I'm also working on Bhagavad Gita, sir. I'm written songs on Bhagavad Gita. Nowadays, nobody's reading. So each chapter I'm making this slow songs type. Those are interested, you can see my site also, sir, website. Thank you.
Namaskar. Thank you for that beautiful exposition on many aspects of the Bhagavad Gita and Mahabharata. My question, because you mentioned about metaphysics a little bit, so I'll just touch upon one small aspect, which is to do with paradox, right? In legal thought also, you have many places where two different kind of, rulings or clauses can have conflicting ideas and thoughts. And in Mahabharata, of course, we have that in many different contexts, in Bhishma Pitamaha's case and in Karna's case and so many other cases. So I would like to know that how do you see the dharmic thinking and the Bharatiya Gyan Parampara helping us in reconciling this discussion of paradoxes, antinomies, and contextuality for that matter, and how can we take that forward?
Well, I think from a Bharatiya Jnana Parampara perspective, there is no the truth. So I think the acceptance of there is no the truth is the beginning of the journey. And then Dharma also is very, very complex. In fact, Bhishma Pitamaha says that what powerful man says becomes the Dharma of the time. That also he acknowledges. So therefore, having this in the backdrop, I think Dharma is something which is very consistent. And my experience with whatever limited understanding and reading that I have, I perceive that your conscience is aligned with the universal Dharma. So therefore, probably that is the instinctive third eye which will take you towards dharma.
मम प्रश्नः श्रीधरमहोदयाय भवद्भिः उपस्थापितेन विषयेन अहम् अत्यन्तं प्रभावितोऽस्मि। मम जिज्ञासा इयं वर्तते यत् भवद्भिः यथा प्रतिपादितं सनातनाः ये विषयाः सन्ति धर्मपदार्थाः ते एव वर्तन्ते, ते आश्वासनस्य विषयाः न सन्ति, अपि तु वास्तविकाः विषयाः सन्ति। कर्तव्यमेव धर्मः इति भवद्भिः प्रतिपादितम्। एतस्यां स्थितौ इदानीं यद् अध्ययनप्रक्रिया प्रचलति अस्माकं लॉ विषये, यद् अध्ययनं प्रचलति तत्र अस्मदीयाः ग्रन्थाः ये वर्तन्ते, यत्र सिद्धान्ताः अपि प्रतिपादिताः, प्रक्रिया अपि प्रतिपादिताः, डिबेट्स् प्रक्रिया इत्यादिकं सर्वं तत्र प्रतिपादितमस्ति। अस्माकं ग्रन्थेभ्यः अयं विषयः कथं न पठ्यमानः अस्ति इति मम जिज्ञासा। तत्र समस्याः काः सन्ति? Let me in Hindi.
I'll try to summarize this. I know some Sanskrit, so I'll try to just tell him what you were asking. This is about the subject and procedure of law. Is that what you were hinting at?
No, no.
Yeah.
Let me Hindi. सर मैं ये पूछना चाह रहा हूँ कि ये जो धर्म माने आपने कहा कर्तव्य है, वो जो है पिता का पितृत्व इत्यादि जो आपने निरूपण किया, इन सभी विषयों को लेकर के एक शास्त्र लॉ व्यवहार शास्त्र जो अपना बना हुआ है, हमारा भारतीय है, जिसको लेकर के हमारे तत्त देश शासन चलते रहे हैं। जैसे हम स्वतंत्र हुए तो एक हमने अलग ग्रंथ लिया, ठीक है, वो कोई बात नहीं, परंतु अध्ययन काल में भारतीय विज्ञान क्या है व्यवहार के लिए, उसको हमें अपने ग्रंथों से क्यों नहीं पढ़ा जा रहा है, जबकि हमारे पास में सारे ग्रंथ हैं, सारी प्रक्रिया है, और वो ऐसी बहुत पुरानी प्रक्रिया नहीं है। जब तक भारत स्वतंत्र नहीं था तब तक उसी प्रक्रिया से चल रहा था। अब जैसे स्वतंत्र हुआ तो वो प्रक्रिया बिल्कुल निरस्त कर दी गई। ऐसा क्यों हो रहा है? उसको अध्ययन अध्यापन में क्यों नहीं लाया जा रहा है? उसमें बाधा क्या है? ये मेरी जिज्ञासा।
मेरे हिसाब से I mean, if I may answer that, what has happened is that post independence we were building a new society based on certain agreed principles which have been summarized in the constitution. So there are underlying values which are embedded in the constitution, which are not expressed, but which are very evident through the epigraphs or the values that they've ascribed to the institutions, their mottos. Most of the national institutions which have come into existence immediately after independence have beautiful slokas in Sanskrit to inspire them. So therefore, at some stage, I think probably a decade or 2 decades later, that decline began. And in fact, I happened to, with the help of a good intern, examine the judgments of the Supreme Court also. So the pattern was that earlier, I think we were not actually as enslaved intellectually in the first few decades of our independence that we became post 70s and 80s. The intellectual enslavement came in along with the amendment to the preamble, as my reading is, socialism, secularism coming into the preamble. Then the ideologies have actually taken over in institutions, and the ideologies were definitely anti-Sanatani. So the घृण्य भावना जो सनातन के प्रति है has been very nurtured, cultivated, propagated, and actually patronized by the people in power. So that was the biggest challenge I think we faced. But people like me are still around, partially understanding a question in Sanskrit, though I'm not trained in Sanskrit. That is the resilience of Sanatan. I think that's the proof of our resilience.
No, just to add to what he was saying, see, when an era comes to a close, we've seen through history that it doesn't come to a close. We say, okay, this day is over, next day. That can't happen easily in very complex histories because of the change that people and societies undergo in all those years. it is not possible to retrace steps that easily. There are certain irreversible changes that have happened. And that is not because of somebody else only. That will be a reason. But when change is inevitable, it takes over society. And retracing steps doesn't happen everywhere at all. It can lead to certain.
जी, जी,
Let's go.
so,
If you
Due
see,
to-
if you see in a larger perspective, why do you see 1,000 years? See 5,000 years. So Mahabharat ke baad, there's a whole India was going on. For last 14 years, there was a problem. Now we got independent. It will still take time. Why are you afraid about what? You see, unless there is antithesis, there will not be thesis. अगर रावण नहीं होता तो राम भी नहीं होता, कंस नहीं होता तो कृष्ण भी नहीं होता. तो अब ये प्रॉब्लम आई है तो we'll solve it. जल्दी क्या हो रही है सर? अपन all institutions are here. अगर इस जन्म में नहीं हो अगले जन्म में कर लेंगे. आप नहीं करोगे और कर लेगा. Why are you? मतलब I don't see. You belong to a culture which is a large culture. यार मतलब why are you getting afraid of what? अभी तो 5,000 साल भी नहीं हुए सर. अपने को तो 311 trillion years है अर्थ की लाइफ. How much you want to live? और रावण बेचारा दुखी था. He lived for million. I don't know whether people are aware कि when Ravan was born, he was born when Hiranyakashipu died, and nobody knows when Hiranyakashipu died. He died in 3rd Manvantara, and he died in 7th Manvantara. जल्दी क्या है सर?
हाँ,
कर लेंगे ना.
We're running short of time.
मुझे विनम्र विनती है, आप पूछ थोड़ा एक विनम्र विनती है. अभी ड्यू टू द paucity of the time, we have शास्त्रार्थ सदस्य धर्मशास्त्र पर लोकक्षेम through पंचभूत संरक्षण is there in the Chandramoleshwara Mandapa from 3 to 6. There also, I request all the scholars to come there. It can happen there also. You can raise some questions there because very learned, highly distinguished scholars of Vedic scholars are coming. So please let us take there. And you can the questions can be taken by personal interaction after this session. And only one question, and this can be answered from off the dais also later, because kindly pardon us.
Decision making is a very important aspect in any kind of judiciary. And also, decision making is a very important aspect in cognitive science. But what I understand, even from Mahabharata and other places, that like Raja Janako, you have to take decisions, so you have to achieve equanimity, like Sthita Brugga. So how can it possible in the present judiciary system? So judges can be like that and he can take decision. And second one, as you are talking about Sanatan Dharma, there is a concept in Rig Veda called Ritam, cosmic order. And it said that after the manifestation of the universe and during the evolution, this cosmic order is maintained at every stage. So if you can shed some light on the present judiciary system, so that we have a kind of,
So the present judicial system has no idea about it. Absolutely no idea. There has been some stray individual judges. I have appeared before about 270 judges of Supreme Court, except for a few here, there, and there. Venkat Chelaiya, Rama Subramanian, people who have got some understanding of the Sanatan Dharma. Again, the same issue. It will take time. It is only 10 years. Our judges who have been appointed now will have come to Supreme Court after 20 years. It will take time. You see, point is that whole cycle has to take place. And suddenly, because ultimately India in 2047 has to become a power, so they will not become power without judiciary support. So we will have the right people at the right time, when the right time.
So may I just conclude, the proof of the pudding is we are about to celebrate the first year of installation of Sri Ramlala in Ayodhya. And that's come through your judiciary.
Thank you, Shri Aruneshwar Gupta ji, Shri Sridhar Potaraju ji, and Shri Amrit Bhargav ji for the insights and an elaborate discussion on collaborative jurisprudence. Now I request Professor Virendra Kumar Pal ji, Director, School of Planning and Architecture, New Delhi, to felicitate the panel members. All of you kindly be seated. We'll have announcements after this. Thank you. With that, after this, we'll be parting for lunch. The next session will be at 2 p.m. It is a panel discussion here on the use of AI and OCR for deciphering handwritten Devanagari manuscripts at the same venue here by Professor